Well, good evening and welcome. I'm Professor Michelle Foster, the Dean of the Melbourne Law School, and it's my great pleasure to welcome you to the 2025 Michael Crommelin Lecture. I'd like to begin by acknowledging that we're meeting this evening on the unceded lands of the Wurundjeri people of the Kulin Nation, and I pay my respects to Elders past, present and emerging, and extend that respect to all Indigenous colleagues with us this evening. I'd also like to acknowledge the tabling of the UROC Justice Commission's report, UROC for Transformation, and the final report, UROC Truth Be Told, which was tabled in the Victorian Parliament in recent weeks. These groundbreaking reports provide a deeper understanding of Aboriginal history and the impacts of colonisation, and they mark a significant step in the relationship between Aboriginal peoples and the state of Victoria within the treaty process. Now, this is the second Michael Crommelin Lecture hosted by the Centre for Comparative Constitutional Law here at Melbourne Law School, which honours Professor Michael Crommelin and his contribution to Melbourne Law School and to public law. Michael Crommelin, AO, is Professor Emeritus and a former Dean of Melbourne Law School, a role he served with great distinction from 1989 to 2002, from 2003 to 2007, and because he was so wonderful, again in 2010. Michael has made and continues to make extensive contributions to legal practice and research in constitutional law, and in particular to the law of energy and resources, a topic on which he continues to teach as part of our Master's Law program here at Melbourne Law School. In 2009, he was appointed an officer in the General Division of the Order of Australia for service to the law and legal education. It is wonderful to have Michael and his wife Roz here with us this evening. I would just like to add a personal note because I am personally indebted to Michael. First, Michael hired me in 2005, and so I owe my whole MLS career to Michael. In my early years as a junior academic, Michael's warmth, generosity and optimism instilled in me a sense of belonging and confidence. And more recently, as I have stepped into Michael's former role as Dean, I have felt nothing but encouraged by his wise and insightful guidance. I'd also like to acknowledge the presence of other esteemed guests. Welcome, Chief Justice of the Federal Court, the Honourable Deborah Mortimer. And of course, a very warm welcome to our guest speaker, former Chief Justice of the Supreme Court of Queensland and former Commissioner of the Royal Commission into the Robodebt Scheme, the Honourable Holmes AC SC. Now, this lecture marks the beginning of the 2025 Constitutional Law Conference, the CCCS's high-level forum for constitutional law discussion that was established in 2009. Tomorrow's sold-out conference, actually I'm not sure if it's sold out, but I thought that sounded great. It's very well attended. Will feature presentations from leading scholars and practitioners on a wide range of significant topics, including native title, Chapter 3 in indefinite detention, and Australian constitutionalism. I'd like to acknowledge the work of everyone at the CCCS, and in particular its co-directors, Professor Adrienne Stone and Associate Professor Will Bartlett, for hosting the conference and this lecture, and for leading important constitutional research and debate here in Australia and abroad. If you'd like to know more about the CCCS, I couldn't resist recommending having a listen to the podcast Constitutional Cafe, a brilliant conversational podcast on constitutional law with an international focus. And now to tonight's event. The order of proceedings for this evening is as follows. I will shortly hand over to Professor Adrienne Stone, Co-Director of the CCCS, who will introduce our guest speaker for this evening. Following Justice Holmes' presentation, my colleague Associate Professor Will Bartlett, Co-Director of the CCCS, will moderate the Q&A and offer a vote of thanks. Once again, I would like to welcome you and thank you for being here, and please do enjoy the rest of the evening. Thank you.
Thank you very much, Dean Foster. It's my pleasure to say something by way of introduction to our speaker and to the lecture. As you've heard, the lecture series was inaugurated 2 years ago to honour the immense contributions of our colleague, Michael Crommelin, who was Dean of this law school, I think, for over 18 years. His contributions to Melbourne Law School, to legal education and to public law. And in his public law career, he focused on many things, but including a strong focus on public integrity. So in that light, when we came to think of a speaker for the second Michael Crommelin Lecture, our minds went very quickly to today's lecturer. The Honourable Holmes was Chief Justice of Queensland from 2015 to 2022. and she had previously had a distinguished judicial career as a judge of the Court of Appeal and of the Trial Division of the Supreme Court of Queensland. But in addition to her service as a judge, Ms Holmes has made immense contributions in other areas. She was a founding member of the Women's Legal Service. She was a member of the Queensland Anti-Discrimination Tribunal and Commissioner of the Queensland Floods and Queensland Floods Commission of Inquiry. And of course, most prominently, over 2022 and 2023, she was the Royal Commissioner for the Royal Commission into the Robodebt Scheme. I hope you'll join with me in extending a very warm welcome to our lecturer for this evening.
Thank you. I'm very pleased and privileged to have been asked to deliver this speech in honour of Professor Michael Crommelin. Like me, a graduate in Arts and Law from the University of Queensland, but unlike me, a distinguished scholar in constitutional law. I, in contrast, preface my talks to any audience, including constitutional lawyers, by pointing out that I am not one. I like to lower expectations early. But it is the start of a conference for constitutional lawyers, so I'm going to begin the talk with a quote from Walter Bagehot's The English Constitution. "The most dangerous of all sinister interests is that of the executive government." You've heard something of my biographical details. I was a judge for 22 years, a role which occasionally involved holding government to account through judicial review or the odd civil suit. But the bitter experience I'm talking about tonight, it probably won't surprise you to hear, came in a post-judicial role when I conducted the Royal Commission into the Robodebt Scheme. It was for me a rather shocking insight into the inadequacy of the mechanisms available to hold the government accountable when it embarks on actions which are ill-conceived, unfair, or contrary to law. To explain the context in which those accountability mechanisms should have been working, I need to give you an account of what the Robodebt Scheme entailed and how it came into being. The relevant Act, the Social Security Act, sets up the conditions for payment of social security benefits and contains rate calculators with income tests. At the relevant time, income was defined as including an income amount earned, derived or received, and it was to be taken into account in the fortnight in which it was first earned, derived or received. So your entitlement to benefit in any given fortnight was determined by reference to the income you'd actually earned or got in that fortnight. The idea was payment on the basis of need, so that although you might have a job for 3/4 of the year, if you then lost it, you'd be entitled to receive benefit, subject to asset testing, for the remaining 3 months. A little more background. At the inception of Robodebt in 2015, there were 2 departments operating in the social services portfolio: the Department of Social Services, DSS, the Senior Department, responsible for policy and legislation, and the Junior, the Department of Human Services, DHS, which did the grunt work of administering programs and benefits. And I observe here that having 2 departments is not a bad way of avoiding executive accountability by siloing information. You have one department saying, "They never told us we couldn't do it like that," and the other department saying, "They never told us they were doing it like that," which allows for some level of deniability, not necessarily plausible. For a couple of decades before Robodebt, DHS, or its precursor, the Centrelink agency, had undertaken data matching with the Australian Taxation Office, matching employer-reported PAYG income for an individual receiving benefits with the income that individual had reported to DHS over the year. DHS could use the information to investigate any glaring discrepancies, ask questions of the benefit recipient, and check with the employer just what was paid and, importantly, over what period. But at the end of 2014, a new Minister for Social Services was appointed, and he promptly had a meeting with the Secretary of DHS, the junior department, at which he raised what politicians and bureaucrats euphemistically refer to as improving the integrity of the welfare system. In 2019, Michael Crommelin and Cheryl Saunders co-authored a paper for the Australian Public Service Review panel, which describes the environment when ministers in a new government encounter the senior public servants they'll be dealing with. There's a lot at stake, the paper says. Expectations are formed and relationships are established. Judgments are made and careers are affected. This wasn't quite that situation. The minister was new, but the government wasn't. And the departmental secretary was actually head of the junior department, not the minister's DSS. But still, you can imagine the conditions that the paper describes coming into play in the secretary's responses. At any rate, DHS did have a proposal for recouping welfare payments, which it set out for the minister in an executive minute. And that was the genesis of Robodebt. It entailed identifying instances where employer-declared income exceeded beneficiary-declared income in any financial year. The benefit recipient, past or present, would be sent a letter which set out the figure for their annual employer-reported income for a given year, usually shown as for the financial year, from July 1 to June 30. The beneficiary would be required to go online and confirm or update the ATO figure provided. If the benefit recipient, who might actually have been off benefit for a couple of years and thought their dealings with DHS long over, if they didn't respond, couldn't produce contrary evidence of their actual income in the period over which it was earned, or, being literal-minded, said that the amount as declared for the ATO for the financial year was correct, the system would income average. It would take the annual employer-reported income, divide it by the number of fortnights in the period the employer had identified, usually the financial year, so 26, and treat that figure, not the figure the recipient had declared at the time of receiving benefit, as the basis for calculating entitlement to benefit, alleging overpayments and raising debts accordingly. The proposal initially contemplated going back over 3 years. Later, that was expanded to 8 financial years. The amount it was touted to recoup from supposed overpayments was about $4.8 billion. The problem's obvious, and it was pointed out in policy and legal advice from the Department of Social Services in 2014 to those who were coming up with this idea, that the Social Security Act provided for entitlement on the basis of actual fortnightly income, which would not be the same as average fortnightly income for an individual unless they received a constant income over the course of the year. Absent that regularity, average income told you nothing about what the individual had actually earned in any given fortnight. In fact, most of those affected by the Robodebt scheme were on either New Start or youth allowance. About 5% of those on New Start and about 2.5% of those on youth allowance actually had stable incomes over the financial years to which the scheme applied. The scheme was contrary to law insofar as it did not apply the statutory income test, as was pointed out by DSS before it began, and was also pointed out subsequently when it began to attract criticism by an internal DHS advice given in January 2017, by a series of AAT decisions from early 2017 on, by a lecture given by Peter Hanks KC at the 2017 Australian Institute of Administrative Law Conference, in 2018 by a paper by Professor Terry Carney and an advice from Clayton Utes, and in 2019 by advice in turn from the AGS and the Solicitor General when it was finally obtained. Besides income averaging, there were other aspects in respect of which there was no legal basis for what DHS was doing in the way it was demanding information from recipients, not within the bounds of the information gathering provisions of the Act, and in the way it was imposing penalties for alleged overpayments. Now, the functions of the executive government are not spelled out in the Constitution. I note that Professor Crommelin once authored a book titled The Enigma of Executive Government. But Section 61 at least makes it clear that they do include maintaining and executing the laws of the Commonwealth. In addition, the Robodebt Scheme was contrary to the policy of the Act of paying on immediate need. It was unfair because it required often vulnerable people to provide evidence of income going back years and expected them to use an online portal requiring a MyGov account to do so. And this was in the years before everybody had to have a MyGov account and did have one. And there were multiple respects in which it just did not work very well, which I don't need to recount here. So there was plenty to be holding the government to account about. Executive government accountability, of course, begins with the Parliament. As I hope I've explained, the Robodebt Scheme entailed a method of income calculation which was not that prescribed by the Social Security Act. To change it required amendment of the Act. An amendment would have entailed retrospectively altering the basis on which recipients were entitled to benefit so as to demand repayment of monies which had been legitimately received. This was a majority government holding 90 House of Representatives seats, so the lower house was unlikely to have presented any real impediment to amendment, but not so the Senate. The budget quote I started with about the evils of executive government comes in the context of a discussion of the value of a second retarding chamber, which he says can at least impede minor instances of parliamentary tyranny. The Senate at the relevant time, thanks to proportional representation, could have been counted on for some vigorous checking and balancing, not to mention retarding. This was a colourful period in which 8 crossbench senators held the balance of power. They included Nick Xenophon and representatives of the Motoring Enthusiast Party, Family First, the Liberal Democratic Party and the DLP, and 3 Palmer United Party senators, one of them Jackie Lambie. A number of measures from the previous year's budget were still bogged down in the Senate. To give you a flavour of the times, in mid-March 2015, about a week before the scheme as formulated in a new policy proposal went to the Expenditure Review Committee, Senator Lazarus, then of the Palmer United Party, made a speech in which he accused the Prime Minister of describing the crossbench as feral. Senator Bill Heffernan raised as a point of order that they were, in fact, unrepresentative swill. But more to the point, the Attorney-General, while denying the PM's name-calling, complained that the Senate had become a house of refusal, not review. So no wonder that the Executive wanted to bypass the Senate. What is scandalous is that it managed it. Where the Executive minute on the proposal delivered to the Minister said clearly that legislative change was needed for the scheme, when the new policy proposal went to the ERC and Cabinet, it contained a statement that the initiative involved no change to how income was assessed or overpayments calculated, made no mention of averaging, and said nothing about any legal impediment, let alone need for amendment of the Act. By this simple obscuring of the proposal's detail and legal consequences, the Senate's overview and its likely obstruction of the scheme's introduction was avoided. The Executive had slipped past the Parliament. But the Senate's oversight role is not limited to review of legislation. Senate committees, recognised in Section 49 of the Constitution, are an important means of holding government to account. As well as Senate legislation committees, which scrutinise bills before the Parliament, there are Senate references committees, which examine particular issues of public concern. By convention, references committees, unlike legislation committees, have a non-government chair and more non-government than government members, so their potential for independent conclusions is somewhat greater. Because of parliamentary privilege, the Robodebt Commission didn't have any occasion to examine the Community Affairs Reference Committee's work, but I've since read with considerable interest the evidence given to its 2 inquiries into the scheme. The first reference to it was made in February 2017, when press coverage of the problems Robodebt was causing was at its height, and the second was in July 2019, after a couple of federal court challenges to the legality of raising debts by income averaging. Generally speaking, the matters referred in each instance concerned the scheme's impact on recipients, the processes involved, and the government's response to the concerns raised, but the terms were broad enough to encompass the legality of income averaging as it was applied in the scheme, and of other aspects of the scheme. The committee's first report in June 2017 recommended that the scheme be paused, a recommendation which the then coalition government cheerfully ignored, while its second report in May 2022 recommended a royal commission. In both references, the committee did a fairly good job of identifying and questioning relevant witnesses. But in dealing with its first reference, it never got near the fundamental question of the scheme's illegality, not only in its use of averaging, but in the way it demanded information from current and former benefit recipients outside the powers under the Act, and in how it imposed penalties. And although by the time the committee was reporting on its second reference in 2022, the issue of averaging's legality as used in the scheme had been resolved by the Federal Court's declaration in the Amato case to the effect that averaged PAYG income information couldn't prove the existence of a debt, the committee could not get to the bottom of whether the government had actually known that before or during the life of the scheme. Nor was it discovered in either inquiry that the entire system, the billions which were supposed to be recouped, was actually predicated on a majority of recipients not responding or not being able to respond to notices so that income averaging could be used to calculate debts against them. Why didn't the committees find those things out? What does it tell us about the limitations on the oversight capacities of Senate committees in general? There are a number of reasons, I think, that they didn't penetrate very far. First of all, DHS stuck to the line it had taken in the new policy proposal submitted to Cabinet. That was that nothing had changed in the way the department assessed income entitlement or debt, adding that averaging was a long-standing practice, and anyway it was only being used as a last resort. Nothing at all had really changed, was the spiel, except the introduction of an online portal to make things very much easier for recipients. There'd been a few technical problems, but the scheme was undergoing a constant process of improvement. By resolutely adhering to that "no change here" mantra, DHS presented a blank wall to inquiry. This required, of course, a public service very much attuned to the wishes of its political masters and not at risk of saying something inadvertent or independent in a Senate hearing. The department's thoroughgoing misrepresentation of what Robodebt actually entailed was very much assisted by an ombudsman's report which repeated all those lines and added a couple, but I'll come to that later. Secondly, the device of taking questions on notice can be a useful means of delaying and obscuring answers. After some time, the answer comes back replete with verbiage and tables of figures, and the immediacy and point of the question has been lost. I read some of those answers with incredulity. I'll just give you one example. In May 2017, a committee member asked what concerns staff had raised internally about the Robodebt process. The answer, if given accurately, would have been very illuminating indeed. But instead, after a while, came a long answer about risk assessments and the department's project management methodology, which in no way addressed the question. I suspect some of the problem for the committee lay in lack of time and resources for its support staff to follow up on questions asked, of which there were admittedly very many. By the time the committee received its second reference in July 2019, it was well aware, because of the federal court challenges, that legality was indeed an issue. And it had now realised from a reference in the Ombudsman's first report that the Minister had been provided with an executive minute about the proposal. Suspecting, correctly, that it was likely to be revealing about the government's state of knowledge, the committee argued that if it could be given to the Ombudsman, it could be given to it. But now the existence of litigation was raised to advance a public interest immunity claim in response to all requests for information and documents which might disclose what the government knew and when it knew it. That continued after settlement of all outstanding court action, on the basis that there might be some more. And here the limitations of Senate scrutiny were sharply exposed, because while the Senate itself repeatedly followed the committee's recommendation to reject the government's public interest immunity claim and to require that the documents be produced either in public or in camera, the government simply maintained the claim and refused to do so. So it seems to me that not just in this context, but more generally, that claims of public interest immunity present executive government with a very effective means of avoiding scrutiny. And a final, though small, hindrance which I observed to effective inquiry by the committees. Parliamentary committees are political. It seemed to me that a lot of time was lost in committee hearings in grandstanding, particularly when the opposition realised it was on a winning streak after the success of the Amato case. Valuable time, which could have been used in forensic questioning, was lost in expostulation and denunciation. But having said that, I have to say in fairness that Rachel Seward, who was the Green who chaired the committee through most of its Robodebt hearings, was very able and very focused. And I have to say the Senate hearings did get public attention, and they did make it evident that there was something there to be uncovered, probably firming up the Labor Party's resolve to hold a Royal Commission should it win office. But here's the thing, having read the evidence and the later answers to questions on notice with the hindsight of the Royal Commission, it strikes me that misleading the Senate in a hearing, while no doubt very serious, may never in fact have much consequence. I did suggest in my report the provision of a copy of it to the Clerk of the Senate and the Chair of both the Community Affairs References and Legislation Committees, which would enable them, should they wish, to compare and contrast answers and approaches. But I suspect it's one of those areas where no one has sufficient time to do any cross-checking, which of course has implications for the effectiveness of the Senate's inquiry powers. Well, that was Parliament's role. 50 years ago, the Whitlam government, recognising the virtues of accountability, put in train the establishment of some extra parliamentary accountability mechanisms. The Commonwealth Ombudsman, the Administrative Appeals Tribunal, the Administrative Review Council, and freedom of information legislation. I've already mentioned the first of those. Many complaints were in fact made about the scheme to the Commonwealth Ombudsman, with the result that his office undertook an investigation into the involvement of both DHS and DSS in the scheme in early 2017, and a later investigation at the end of 2018, beginning of 2019, to check on the implementation of the office's earlier recommendations. The Ombudsman's Office began promisingly in 2017, advising that it would be looking at adherence to legislative requirements. In particular, how DHS was ensuring that its assessment of income data and decision to raise a debt complied with the Social Security Act. It very early asked both departments for copies of any relevant legal advice. The Ombudsman did not use any of his coercive powers. His investigation was all done on an ask nicely and they will tell you basis, assuming that the departmental officers would cooperate fully, with a surprising receptivity to DHS suggestions as to how the report should be drafted. The trouble was that the departmental officers responding to his questions were those who'd waved the Robodebt scheme through in 2015. The Ombudsman's draft report did originally raise concerns about at least this, the failure to obtain external legal advice on the legality of averaging. But DHS maintained its line that nothing had changed in its modus operandi, and the Ombudsman was impressed by a letter from the Secretary of DSS, the senior department, which assured him that the scheme operated in line with legislative requirements, in so many words. Unfortunately, the Secretary had actually done nothing to check whether that was true. In addition, DSS hurriedly arranged for some cobbled-up internal legal advice and gave a very unconvincing explanation, unchallenged by the Ombudsman, of why it had changed its view of the scheme's legality since it gave its 2014 advice that income averaging as used in it would not comply with the Act. In the result, the Ombudsman decided it would be better to get the report out quickly, with recommendations addressing some of the many technical problems that were bedeviling the scheme and its subjects, and leave the lawfulness of income averaging alone. Unfortunately, he chose to include in the report a statement that the business rules supporting the debt calculation in Robodebt accurately captured the legislative and policy requirements. This was subsequently explained as an attempt to convey that the rate calculators had not changed. And it's true, the rate calculators were the same. It was the way the income test was being applied that had changed dramatically. But this statement in the report was then cited by ministers, politicians, departmental officers as independent authority for the legality of Robodebt. As to the methodology of averaging, the Ombudsman did suggest in a draft report that there was potential for inaccurate debts to be raised, but removed that passage at the suggestion of DHS. Instead, he made the point correctly that if the benefit recipient could collect his or her information and enter it properly into the system, Robodebt could accurately calculate the debt. But he'd been fobbed off when he asked what percentage of debt had been calculated, not like that, but by averaging. The true answer at the time, as DHS knew, was about 76%, although it was to rise a little. The Ombudsman, however, was told the information was not available, which he didn't question, and he accepted DHS' quite untrue claim that averaging was only used as a last resort. So in his report, he simply asserted that he was satisfied that the debts raised by the system were accurate based on the available information, with the hollow qualifier that if the information were incomplete, the debt amount might be affected. What he said then was later used then as a basis for asserting the accuracy of Robodebt calculations at large. The Ombudsman who was investigating in 2017 was in fact acting in the position, which may explain a certain hesitance to make waves. And I suppose that's a problem where investigation is to be done by someone who doesn't have the confidence of a permanent position. But a later Ombudsman, formally appointed to the substantive position, was not noticeably more robust. In 2019, I've mentioned this report earlier, the Ombudsman produced a report on the implementation of the recommendations the earlier report had made for the improvement of Robodebt. He provided DHS with a draft which noted arguments that the use of averaging was legally flawed, other people's arguments that the use of averaging was legally flawed, and said that this was a question which would require resolution by the court. The report also suggested that it might be a good idea to get external legal advice before putting in place a program where the legal position was not entirely certain. But a meeting with the Secretary of DHS convinced him to remove that section altogether on the specious basis that there was a case on foot in the federal court. Once again, DHS had got what it wanted from the Ombudsman. Now, this is not the United States. The government had not installed a partisan head of this investigative agency with a mission to run the government line, however remote from reality. These ombudsmen no doubt felt that they could assume that other public servants were well-intentioned and responding to the best of their ability. They had to operate in the Canberra world and felt it better to achieve what they could without confrontation. But the outcome, from the government's perspective, was just as good and the result just as disastrous if they'd actually been installed to advance the government's deception. Because the initial reporting and the subsequent failure to raise any fundamental problem with the scheme served as a continuing shield against criticism of Robodebt. The government's response to the Senate Committee's first report simply pointed out, in relation to each issue, that the Ombudsman had investigated that and found no major problem. And that was the response thereafter to complaints by members of the public, agencies working in the area, the media, and other politicians. It was the answer to everything. The Ombudsman were not just ineffectual, but helped to ensure that Robodebt had a much longer life than it might have. This is an example of bitter reality, how theory and practice can diverge. In theory, what could be better than a body whose function is to ensure that executive action is legal and fair? But the reality was its manipulation into being used as a cover and support for action that was neither legal nor fair. So not a very successful accountability mechanism there. Now I come to the role of freedom of information legislation in promoting accountability. Individuals were, of course, able to get their own files. The trouble was that the data calculation process evidenced in them was, by design or ill fortune, extraordinarily difficult to understand without expert help. But as a means of uncovering what was involved in Robodebt more widely, FOI was virtually useless and no doubt would be again should a similar scenario arise. In January 2017, Justin Warren made an application under the Freedom of Information Act for new policy proposals and costing documents related to the scheme. He had some success with the Information Commissioner, but the Administrative Appeals Tribunal overturned that decision, finding all documents sought exempt on public interest immunity grounds. Unfortunately, it didn't manage to reach that decision until December 2022. The decision was later set aside in the full federal court on procedural fairness grounds and returned for review, but that was not until June 2024, by which time it was all over, bar the shouting. The documents had been known through the Royal Commission. There was no assurance, had that not occurred, that Mr Warren would have been able to get past public interest immunity to get hold of them. So that 7-year journey is no advertisement for finding out what the government's been up to through FOI. I did propose in my report that for freedom of information purposes, cabinet confidentiality as a basis for exemption from production be maintainable only where reasonably justified for an identifiable public interest reason, which landed like a lead balloon. What about the other Whitlam-era initiatives? Well, of course, there's nothing like a good merits review tribunal to get to the bottom of where the government is going wrong in its administrative decision-making. Recipients who had the capacity and robustness to challenge DHS debt decisions, which I'm afraid was a minority, could do so in the Administrative Appeals Tribunal, members of which should have had sufficient knowledge of the Social Security Act to identify the flaws in the Robodebt methodology, and some did. But the way that tribunal was structured and the way DHS managed the decisions which were adverse to it meant that the tribunal did not offer a coherent and, more importantly, accessible response. The tribunal had 2 levels, a first instance tier which didn't publish its decisions and a review tier which did. The first tier heard the applications for review of Robodebt decisions. Some members just checked that the DHS averaging calculations were correct and confirmed the decision, but a majority actually did not accept calculations based on averaging, with a much more select group giving reasoned decisions on why the income test under the Act did not permit it. There should have been a few ways in which those decisions on legality had an impact. First of all, you would think that they would have some persuasive effect so as to produce a uniform approach by the tribunal, as its less legally minded members came to know about them. But if there was any organised communication between the tribunal members on the topic, it's not apparent. And of course, the decisions weren't published. And DHS, although it was supposed as a model litigant to ensure that the AAT was aware of all relevant information and arguments, didn't consider that these decisions setting out reasoning as to why averaging was not permitted by the Act warranted bringing to tribunal attention. Secondly, there should have been oversight by the senior department, DSS. The Secretary of the Department of Social Services is actually required under the Act to have regard to relevant decisions of the AAT in administering the Social Security law. And it was the Secretary in whose name applications for review, or appeals as DHS called them, were made to the second tier of the AAT. DHS was responsible for referring matters to DSS for appeal, but as well as that, it was required to refer to DSS any unfavourable AAT decision where there was a significant error of law, of policy, or of administrative practice, or the matter was likely to attract media or parliamentary attention. Now, you'd think a few of those targets must have been hit. You had what could have been a real means of overview, the provision for the senior department, DSS, to keep an eye on the AAT decisions. But DHS never recommended an appeal and didn't refer any decision for information until mid-2018. And DSS was not asking. But surely DHS had to recommend that the Secretary of DSS appeal those decisions which said that averaging as it was being used was contrary to the Act, if the department thought that the tribunal members were getting the law wrong. No, DHS simply accepted the outcome in money terms and ignored the law as expounded in those cases. It proceeded on the basis that those decisions involved no legal error and should not be appealed, while simultaneously maintaining its own legal position on which the scheme was operating, that averaging was legal. Touchingly, the department's chief counsel's explanation for ignoring its own guidelines for appeal was that it had to be a model litigant and it didn't want to go putting recipients through the trauma of appeal processes. That contrasts with advice a senior DHS lawyer gave in 2018 when DHS finally did refer a decision to DSS for information. He recommended against an appeal because, and I'm quoting, it would put criticism of the averaging methodology into the public arena, and those arguments would have to be addressed, with the risk that the scheme's whole approach would be undermined. DSS did appeal the adverse decision and then obtained advice from Clayton Utz, which pointed out that the Act did not permit averaging as it was being used. DHS and DSS's response on this, the appeal was withdrawn and the advice was suppressed. So the first tier AAT decisions on legality were kept safely under wraps. And unfortunately, another Whitlam accountability mechanism, the Administrative Review Council, the design of which contemplated scrutiny of administrative issues and which might have provided some interesting scrutiny here, had been defunded in the same budget which introduced Robodebt. Having begun with the Senate, I come now to the other constitutional check on executive power, the judiciary. As we've seen in the United States, when all other means of restraining the excesses of executive government fail, there are only the courts to look to. To which you may say that doesn't seem to be working so well for them. However, Australian judges of higher courts, although unlike US federal judges directly appointed by executive government, tend in my observation to exhibit a strong streak of independence and a general indifference to the finer feelings of the government which appointed them. for which I think credit is largely due to the traditions of independence of the bar. But as the Honourable Robert French observed in the inaugural Michael Crommelin Lecture, the judicial process is an ad hoc mechanism of accountability, and it's beyond the means of the average punter. Still, here we can rejoice in a righteous government agency, your very own local legal service, Victoria Legal Aid. Had it not been for its lawyers' dedication and determination, it's unlikely that the two women who did ultimately bring challenges to the legality of Robodebt in the federal court would have been able to do so. Even then, DHS set out to stymie the first application for a declaration by, on very flimsy grounds, reducing the applicant's debt to zero, so it could argue there was nothing remaining to be determined. It attempted the same technique in the second case, but was thwarted by the applicant's claim for interest on the money that had been recouped from her, which meant that there remained a live controversy for resolution. DHS obtained a long overdue opinion from the Solicitor General, which resulted in a declaration made by consent that, in effect, the evidence of averaged income could not prove a debt in that case. And it led to the government announcing that it would no longer rely on the methodology as the sole basis for claiming the existence of a debt, which in turn prompted a class action. It was settled with the government admitting that it had no proper legal basis for raising debts by income averaging, reimbursing those who'd paid debts, and writing off the debts of those who had not paid them. I won't dwell on how much all this cost. The settlements in the Amato case and the class action were inevitable and hence appropriate, but they had the advantage for the government that they avoided any hearing of evidence. Court action did then lead to some accountability in the monetary sense, although it in no way compensated for the misery of those caught up in the scheme. But it did not bring to light much of what had actually caused the disaster of Robodebt. The class action settled in 2021. I've been trying to stick more or less to a timeline, and I'll continue to, but the accountability sequence gets a little out of order if you regard accountability as requiring not only exposure and attribution of responsibility, but consequences. There's really only one relevant consequence for executive government as opposed to the individuals involved in it. And I suppose you could say that the ultimate in executive government accountability arrived the following year in 2022 in the form of the coalition's rejection by the electorate at that year's election. I don't suppose that Robodebt was responsible, but I don't think it helped. However, I observe that for electoral accountability to have real meaning and force, the electorate has to know what its government has been doing. Hence my focus on scrutiny and exposure and attribution of responsibility in this lecture. The newly elected Labor government did two things of significance in accountability terms. It established the Robodebt Commission and it established the National Anti-Corruption Commission. Speaking generally, the Royal Commission can be a very effective accountability mechanism because of its power of summoning witnesses who can't claim privilege against self-incrimination, and because of its ability to obtain documents. The latter is particularly significant given that the public interest argument now has a different dimension. You're now in a context where the government has acknowledged that there is a public interest in the investigation of this. The starting hurdle is that you need a government in place that wants to hold one. And there's this too. Royal commissions and commissions of inquiry, I should say at the start, they can have massive impacts both in producing accountability and maintaining it. I come, as Michael does, from Queensland, where you can really divide political and public administration in the state into pre- and post-federal Fitzgerald inquiry. But I want to say Royal Commissions have their drawbacks, and I think in general must be regarded as a last resort. It's expensive, And when it's into the workings of government, the demands on departments for information and production of documents have the potential to cripple their capacity to carry out their normal activities. In Robodebt, the Commonwealth produced nearly 1 million documents, although remarkably few actually documented decisions key to the scheme. Fascinating though the frequent flyer statements of senior executives were, I was never entirely clear why they produced those. And although a lot was uncovered in the Commission, I don't flatter myself that I got to the bottom of everything. There was no whistleblower in senior ranks, and there was a lot of failure of recall. On the other hand, members of the executive government had to give an explanation, an account of their conduct under public scrutiny, and I think that was important. And I can point to some positive accountability outcomes from the Robodebt Commission. According to the government's implementation update, there's some revision of cabinet procedures. New policy proposals must indicate whether legislative change is required in order for the proposal to be lawfully implemented, and whether the Australian government solicitor has reviewed and agreed with any legal advice on legislative changes. Cabinet is to be provided with summaries of any legal issues and made aware of what legal advice has been obtained, from whom, and in respect of what risks. Departmental heads and public servants now have a statutory duty to use their best endeavour to assist the Ombudsman in his or her inquiries. And here's a breakthrough. Responses to investigations are not to be led by those involved in the matters under investigation. The Ombudsman's been given additional power to obtain information, and the Public Service Commissioner has a new power to commence his or her own motion investigations into Public Service Code of Conduct matters. There are other changes to the Code of Conduct designed to promote public service independence, but matters of culture can be quite hard to shift by regulation. The AAT was always on its way out with the Labor government, so I don't credit Robodebt for that. But importantly for our purposes, there are some ongoing changes in respect of its replacement, the ART, which I think do come from Robodebt. Its members are required to identify and report systemic issues in administrative decision-making, and significant decisions will be published, and the Administrative Review Council is being reinstated. And I should mention this doesn't come out of any Robodebt recommendation. This is a piece of information, really. On the issue of departmental oversight and siloing of information, Services Australia, the agency which replaced DHS, was folded into the senior department, DSS, in 2019 after, and probably because of, the Robodebt debacle. A couple of weeks ago, however, it was moved into the Department of Finance, and with it, DSS's role in government service delivery policy. DSS retains other policy areas, such as income support policy. So it remains to be seen how oversight and interaction under that arrangement works out. Final accountability mechanism. The National Anti-Corruption Commission came into existence just about the time my Royal Commission was winding up. The relevant Act's definition of what constitutes corrupt conduct by public officials is a broad one. If the Commission had existed throughout Robodebt, there's a reasonable chance that more junior public servants might have taken complaints to it. It would have encountered many of the same problems I did in terms of senior executive service obduracy and lack of documentation, but it would have had the advantage of a contemporary investigation. It may be that it could have investigated and reported on Robodebt in such a way as to stop the scheme in its tracks. I'm afraid the lecture has been long on bitter experience and short on theory, but I feel safe in assuming that this is an audience well versed in theory anyway. What do I draw from the experience? Our system of safeguards against executive government excess and impropriety is frail and sluggish. Executive government can brazen its way through for quite a long time if it's backed by a compliant senior executive service and unchallenged by timid investigative agencies. The legislative arm, depending on the state of the two houses, may never be the source of a breakthrough. The best chance for a reckoning is through the courts, but that'll take time and it's unlikely to be complete. Maybe the NAC will provide an answer. Time will tell. In closing, once again, this isn't the United States, for which we can all feel relieved and perhaps a little smug, but perhaps also a little apprehensive, because that example shows what can happen where an executive with a captive legislature in both houses wields the power of appointment and firing of the public service in the context of a constitution which is open to different interpretations about the extent of executive power. And that's where I end. As Donald Trump says in his tariff letters, thank you for your attention to this matter.